Good afternoon, everyone. Welcome to the CIL webinar on maritime security and commercial shipping, approaches of the IMO and ASEAN. Good afternoon to you all from Singapore. And today we are joined by a wide range of participants from all over the world. I expect that some of them may be coming in a little bit later, but the participant number is surely going to grow in a few minutes. And to those of you who are joining us from afar, from outside the ASEAN region, good morning, good afternoon, or good evening to you all. To kick off our discussion on maritime security and commercial shipping, I am pleased to invite to deliver welcoming remarks CIL's very own director, Dr. Nilofer Oral.
Thank you. Thank you so much, Pia. And may I extend a very warm welcome and greetings from CIL in Singapore. It's really a great pleasure to be making a brief opening comments to this very interesting and important webinar. Of course, CIL considers itself as one of the leading centers for research on international law, and particularly on oceans law and policy. So I want to first of all acknowledge our speakers today, and in particular, we have Professor Robert Beckman, who to many of you probably doesn't need any introduction. He is really one of the leading names and scholars in maritime law and law of the sea. And he was formerly the director of the CIL and the founder of the CIL, but currently heads the Ocean Law and Policy Program. I also want to thank our moderator, Pia Benoza, who made the introduction, who is a distinguished research associate with us at CIL. And last but of course not least, Dr. Dang Hai Vu, who is a senior research fellow with the Ocean Law and Policy Program, and who will also be joining Professor Bob Beckman as one of the speakers. And this is an issue about maritime security, and I think it's really fascinating, and I suspect perhaps a different perspective, because the webinar will be looking at not just the IMO, the specialized agency for the UN, and how it looks at security issues in relation to commercial shipping, but ASEAN. ASEAN, because obviously maritime security is a very important issue in this region. So what is the ASEAN perspective? And we have excellent experts today to speak to us about that. So I thank you all for joining us, and I look forward to listening to this very interesting webinar as well. Over to you, Pia.
Thank you very much, Dr. Oral, for getting us to a good start for this program. We have received a couple of questions and comments from the registration for this webinar. So we would like to invite all of our attendees here today. If you have any thoughts that you would like to share, please do make use of the chat box, and or give some of your comments later on when we have the open forum. We will have a little over an hour for the presentations of Dr. Beckman and Dr. Wu Haidang, and then the rest of the time will be for our discussion. Without further ado, I would like to give the floor to Professor Robert Beckman.
Thank you very much, Pia. I'd like to share my screen. Talking not only about the IMO framework, I'm talking about the global framework on the security of shipping, because in preparing, I decided looking only at the IMO would be too narrow. So I'm going to look at the global framework of security of shipping with Southeast Asia in mind. And now, for whatever reason, importance of UNCLOS, 1982 UN Convention on Law of the Sea is part 1. Criminal jurisdiction over ships under the 1982 Convention. The general principle is that ships on the high seas are subject to the exclusive jurisdiction of the flag state. The only exception is piracy under the law of nations. Outside the territorial sea limits of any state, which means outside the 12-mile territorial sea limit, warship of any state may seize a pirate ship, arrest the pirates on board, and seize the property on board. That is the only exception. An attack on a ship in waters subject to the sovereignty of a coastal state, meaning internal waters, territorial sea, or archipelagic waters, is not piracy. It's governed by the laws of the coastal state or archipelagic state. And the only state with power to arrest ships is the coastal state, unless the coastal state authorizes another ship. Coastal states and archipelagic states have the exclusive right to exercise police power over ships in their ports and internal waters, in their territorial sea, and the archipelagic waters. So that's the legal framework we're dealing with. And to put it in the context of Southeast Asia, that means because under a 1970 treaty on the territorial sea, from the down here at point number 1, if you can see my cursor at the lower half of the Malacca Strait, is entirely the territorial sea of Malaysia or Indonesia. And therefore, any attack on a ship in that area, it cannot be piracy. It would be crime only under the laws of the either coastal state, and it would be the coastal state in whose territorial sea the attack took place that would have exclusive police power over the event. Territorial sea between Indonesia, Singapore, and Malaysia in the Singapore Strait. This is taken from the official Indonesian map that's online. Again, it shows that the entire Singapore Strait leading up to the Strait of Malacca in the west and leading to the South China Sea in the east is the territorial sea of one of the 3 littoral states, either Malaysia, Singapore, or Indonesia, and therefore there can be no piracy because it is attack on a ship would be governed by the laws of the state in whose territory the attack took place. Indonesia, notice the vast Indonesian archipelago with more than 16 or 17,000 islands. Under the law of the sea, Indonesia is able to draw a straight baseline connecting the outermost points of their outermost islands and drying reefs. It measures a 12-mile territorial sea from there. Therefore, all of the light green area you see is the archipelagic waters of Singapore. There's then a thin red line connecting the outermost points of the outermost islands and reef. That would be the territorial sea. And then another 12 miles of light green after that would be the territorial sea. So any attack in this area would be not piracy. It has to be under the laws of Indonesia. I drew a circle up there in the Natuna Sea area because what you see is the 2 parts of Malaysia are separated by the Natuna Islands, which belong to Indonesia, and therefore a ship moving from the Indian Ocean to the South China Sea is going through Indonesian waters that lead all the way up to the Natuna Islands before it can be piracy. It would have to be the dark blue area before it would be piracy rules would be applicable. I think we need that context in order to understand the issues. Again, this is that Natuna area in more detail. The red line is the archipelagic baseline of Indonesia. The orange line following it with their 12-mile territorial sea. You also see to the left of the screen off the peninsular Malaysia, their territorial sea from peninsular Malaysia. Again, any attack inside the landward of the orange lines would not be piracy. It'd be governed by the coastal states' laws, but area between the or seaward of the orange line, the piracy rules would apply. I think we must understand that framework for law of the sea in this region. There's, again, the Sulu Sea and the Celebes Sea. There were incidents to show you later of the taking of hostages of ships in this area by Abu Sayyaf guerrillas. But again, this is not governed by, attack on those ships would not be piracy. It'd be governed by the national laws of Philippines because it occurred in their archipelagic waters, or to the south in the Celebes, the archipelagic waters of Indonesia. This is a map of the South China Sea. Again, it shows the territorial sea lines along the land areas, obviously in yellow. The territorial sea is in dark blue. There's then a 12-mile territorial sea, and it's any of those areas, the laws on piracy would not apply. This is in the lower left-hand corner. It shows the Natuna Sea up to between Malaysia and east and west Malaysia. Now, on Part 2, I'll move with that background to move to the IMO and its responses to threats to maritime security. The IMO is the UN specialized agency responsible for the regulation of commercial shipping. Its objectives to provide machinery for cooperation among governments in the field of government regulation and practice relating to technical matters of all kinds affecting commercial shipping. The goal is to encourage and facilitate the general adoption of the highest practicable standards in matters concerning maritime safety, efficiency of navigation, and prevention of pollution from ships. So when it was established, the security of shipping was not on the list. It was safety and ship source pollution. IMO conventions, or the UN conventions, I'm moving a little bit from the IMO because beginning in the 70s, United Nations, through special treaties, adopted conventions, another word for a treaty, to make certain acts international crimes among the contracting states that are parties to that treaty to address particular threats. The first was the Hague Convention for the Suppression of Unlawful Acts against the Seizure of Aircraft, so-called Hijacking of Aircraft Convention. One that is relevant to some attacks on shipping is the 1979 Convention against taking of hostages. One which is, we'll see why this was passed, the 1988 Convention for the Suppression of Acts against the Safety of Maritime Navigation. This is the first instance in which the IMO became involved in the security of shipping. We refer to that as the 88 SUA Convention. Later, they adopted the 1999 Conventions for the Suppression of Financing of Terrorism. Notice the word there's terrorism. Even though those first three conventions, there was no terrorist motive required. It didn't have to be terrorist. It was simply making the acts unlawful among the contracting parties. Now, again, we see some of the acts of siphoning in which would have been SUA offenses, SUA convention offenses, 2011 to 2014. This is taken from a recap map, but most of those incidents were in areas not where the piracy rules apply, where the territorial laws of the state, coastal states applied, but if they had been parties to the SUA convention, they also would have been potentially offenses under that convention. There were other incidents in South China, in Southeast Asia, the abduction of crew members in the Sulu Celebes area, which I showed you later, is within the archipelagic waters of either Philippines or Indonesia. period between reported by RCAP between 2016 and 2017, abduction of crew members. This is the case where, again, one of those international conventions on the taking of hostages would apply if the parties to the in the region were all parties to the hostages convention. But it wouldn't be a case of piracy because the acts were occurring in waters inside the sovereignty of the coastal states. Now, the IMO and maritime security, international organizations often react to I tell my students two things. They react to a crisis, or they often act with changes in environmental consciousness. With respect to security, the IMO has reacted to crises. The first IMO convention that I mentioned was a reaction to the hijacking of an Italian flag ship in the Mediterranean by Palestinian terrorists who boarded as passengers. And what they found out that it wasn't piracy, because piracy requires two ships. Must be the persons aboard one ship attack another ship. And this was passengers attacking or taking over the ship which they had boarded. Therefore, it wasn't piracy. And in response to that, the IMO passed another convention on international crime similar to the SUA convention, similar to the hijacking of aircraft convention. And it followed the same model, except it created a different offense or act against the safety of maritime navigation. And because it involved shipping, it became an IMO convention. And the IMO from that point started to incorporate a little bit of, they're still calling it safety of maritime navigation, because the mandate of the IMO is only safety, not security. But it's suppression of unlawful acts against the safety of maritime navigation. All parties to that convention would make attacks on ships which endanger the safety a crime under their laws. They have no special power to arrest the perpetrators, but if they come into their territory, they must take them into custody and either arrest them or either prosecute them or extradite them. The other major response of the IMO on security of shipping followed the 9/11 attack on the World Trade Center in 2001. After that, the IMO began to incorporate security under safety. So again, they started to reinterpret its mandate in light of the threat to shipping that was posed by terrorist acts. It did two things that were major. In December 2002, it approved amendments to the SOLAS Convention Chapter 11 and put a new chapter in SOLAS Convention establishing the International Ship and Port Security Code. So two areas that they moved. The third area they moved on was the 88 SUA Convention, and protocol was added to it to include terrorist offenses or acts against using a ship for a terrorist offense, or attacks terrorist offenses against ships. So they expanded the mandate of the 1988 convention. But again, it's only among contracting parties. 205, again, IMO reacted to crisis by looking at the Somali piracy in the Gulf of Aden, and that's where they developed the code of practice for crimes against piracy, and the term that was created by them then, armed robbery against ships, which I'll say more about. Armed robbery against ships is same definition of piracy, except it occurs in territorial sea or archipelagic waters rather than seaward or an economic zone or high seas. Now, the SUA Convention, to come back to that, one of the several conventions on maritime crimes adopted by the IMO after the Achille Lauro. All states parties to these conventions, this is the key. It's universal jurisdiction, I call it, among the state parties. All of the parties agree to make the crime defined in the convention criminal offenses under their domestic law. They also agree to give no power, no special power to arrest people other than if the perpetrators enter their territory, they must arrest the alleged offenders in their territory, and they must ensure their presence in the territory. And then number three, you only have two choices. You must either extradite them to another person with jurisdiction, another state party to the convention, or prosecute them in your own court. That's the choice, extradite or prosecute. And then the parties create an offense for the precise offense defined in that convention. Another obligation, of course, they must cooperate with each other in any criminal procedures, either in the state that has arrested them or the state where they eventually are prosecuted. Now, in response to the terrorism attack in 2001, series of measures were taken by the IMO, amendments to Chapter 11 of SOAS, ISPS Code, 205 Protocol to the 88 SUA Convention. And following these measures, the IMO conventions that were previously described as conventions on international crimes, because many of them don't require any kind of terrorist motive or objective, but all these conventions on international crimes became referred to in the international community as the UN Counter-Terrorism Conventions. Even though, like the SUA Convention or the Hostages Convention, there's nothing really to do with terrorism. If you take someone hostage, you're committing a crime. You don't have to be terrorists, or you don't have to have a terrorist motive. Now, because and I believe this is an unfortunate development, but because the 88 SUA Convention and Hostages Conventions are labeled as terrorism conventions, even though they cover acts that have nothing to do with terrorism, some states are reluctant to ratify them because they don't believe that people that commit these crimes are terrorists. Well, they aren't terrorists, but they would be creating an offense if you ratify the convention. So this is one of the downsides of the international communities beginning to call all of these conventions any counterterrorism convention. Now, the 205 SUA Protocol was the one international convention that was specifically designed to deal with the threat of terrorism, threat to commercial shipping from terrorist acts. It was amending the 88 SUA Convention. It created new offenses, and those new offenses including terrorist attacks on ships, using ships as a weapon in terrorist attacks, etc. It creates a cooperative framework exactly the same as the other UN so-called counterterrorism conventions. In other words, you don't have any special powers to arrest outside your territory, but if the perpetrators enter your territory, you must arrest them and ensure their presence and then either extradite or prosecute them. It's consistent with the principles in UNCLOS, an exclusive jurisdiction of the flag states, because it doesn't change the rules in UNCLOS on arrest of ships or persons on board ships at all. Establishes a framework for cooperation among state parties. And unfortunately, the convention through a protocol has only been ratified by 45 states, and no states in East Asia or Southeast Asia are parties. My own cynical view on that is that potential for maritime terrorism was a hot item in the international agenda after the 9/11 attack, but we've been fortunate in the international community that we haven't actually seen ships being used as terrorist weapons, etc. There haven't been terrorist attacks on shipping, and therefore states have put this issue on the back burner and they have not ratified the SUA protocol. Be happy to answer questions on that. Part 3, I'm going to talk about piracy and armed robbery against ships. This is the IMO and piracy. IMO has been concerned with the threat of piracy since the late 1990s and early 2000s. And the first area of concern, geographic area of concern, was Southeast Asia, especially acts against the Straits of Malacca and Singapore, acts against shipping in the Straits of Malacca and Singapore and Indonesian waters. IMO concern then shifted to Somali piracy in the 2005 or so. IMO focuses now on piracy in West and Central Africa, especially off the coast of Nigeria. Now, the IMO response, they did not adopt any new treaties to address the threat to security of shipping. They adopted, with respect to piracy and armed robbery. After 9/11, they had new treaties as amending the SUA protocol, but they didn't adopt any new treaties to address security threats from piracy. IMO addressed the threat of commercial shipping as one of what they call piracy and armed robbery against ships. Definition of armed robbery against ships is exactly the same as the definition of piracy, except that it takes place in waters subject to sovereignty of the coastal states. Therefore, technically, there's no armed robbery against ship offense unless it meets the very high standard of violence required by the definition of piracy. It must be an illegal act of violence or detention or an act of depredation. That's a fairly high standard. And if you look at the vast majority of boarding, unauthorized boarding on ships in Southeast Asia, they don't really meet this threshold because sometimes the perpetrators are simply coming aboard the ship and stealing spare parts and then leaving. There's no illegal act of violence or detention or act of depredation, and therefore the offense is neither piracy nor armed robbery against ships in a technical manner. IMO documents on piracy and armed robbery in ships don't make any exceptions to the UNCLOS rules on jurisdiction. Exactly the same. Restraints on the IMO in addressing piracy and armed robbery, the major IMO conventions on ship safety and ship source pollution are universally accepted. The IMO conventions like SOLAS, COLREGs, MARPOL, etc., almost universally accepted, and they're implemented by the flag states. And when the IMO amends their annexes to any of the major conventions like SOLAS or MARPOL or STCW, the annexes automatically bind all states parties under the tacit acceptance procedures in the conventions, and therefore 98% of the world's tonnage of shipping immediately must comply with the annexes. By contrast, the IMO resolution on a code of practice on piracy and armed robbery against ships is not legally binding. It's not part of one of their major conventions. And to implement the code of practice, the IMO relies on cooperation among states, or possibly with also the assistance of regional bodies like RCAP, which I'll explain in a minute. So the IMO measures following this, the Djibouti Code of Conduct for Repression of Piracy in the Somali Piracy in the West Indian Ocean and Gulf of Thailand, much more serious than the incidents we had in Southeast Asia. IMO's also issued guidance to ship owners, ship operators, ship masters in order to prevent piracy, hardening the vessels, etc. There's been code of conduct to repress piracy aimed at owners and operators as well as coastal states, and recommendations to governments to prevent and suppress piracy and armed robbery against ships. These have made some have a very good impact because they've enabled flag states and owners to take steps to cooperate sometimes with coastal states to prevent piracy from occurring. In this region, we have the RCAP agreement. IMO encouraged regional cooperation. It's been done in this area through the 205 Regional Cooperation Agreement on combating piracy and armed robbery against ships. The focus is Asia, not just Southeast Asia, but East Asia and South Asia. And the 21 parties to the RCAP agreement include not only the states from Southeast Asia, East Asia, and South Asia, but some of the parties are also the maritime powers from Europe and North America. So it's a regional agreement in a sense. The target area is Southeast Asia, but in fact, and East Asia, South Asia, but in fact includes members from Europe and North America as well. The RCAP Information Center was established in Singapore in 2005, focuses on enhancing cooperation to combat piracy and armed robbery against ships, as defined by the IMO, but it collects data on all attacks and unauthorized boarding. Because I said before, it's my analysis that most of the incidents in Southeast Asia don't meet the level of violence required for either piracy or armed robbery. The RCAP Information Sharing Center has developed their own criteria to categorize the seriousness of the attack on the ships, but they're not categorizing them in terms of the other the other international conventions. They're not looking at whether it's also a SUO offense or whether it would be a hostages convention offense, etc. Vast majority of attacks in Southeast Asia don't meet the threshold. Nevertheless, the cooperation to prevent any attack, because any attack is a threat to the safety of the crew members. So the RCAP has done a good job at focusing between using the maritime powers and shipping organizations to try to enhance, and the ship owners to try to enhance security. My conclusions: this presentation was intended to lay down the sort of the global framework from which the measures taken by ASEAN and the security of shipping can be evaluated. The global response to security of shipping should be analyzed in light of the legal framework in UNCLOS on jurisdiction over ships, critically important. And the global response has been a mix of so-called, what we now call counter-terrorism conventions, but also IMO guidelines and regional cooperative arrangements. Thanks very much for your attention. Happy to take questions either now or after the second presentation.
Thank you very much, Prof. I think we are going to reserve the questions for the end of the discussion.
Okay.
But you are free to, everyone is free to type in the Q&A box, and our speakers can also see those questions. So I invite everyone to do so if they wish. So thanks very much again, Prof, for giving us that legal and historical framework on security threats to commercial shipping. I think an important takeaway is how you discussed how IMO's mandate has evolved to take into account crisis situations or changes in environmental consciousness. We also did hear a little bit from your presentation on the current status of IMO instruments in Southeast Asia and efforts by relevant actors in the region. So to give us more on this front, I would now like to give the floor to Dr. Vu Hai Dang, who will specifically tell us about approaches of the ASEAN to the same commercial threats to commercial shipping.
Can you see me well and hear me well, Pia?
Very well done.
Thank you. Ladies and gentlemen, please fasten your seatbelt and embark with me for a tour to Southeast Asia. ASEAN has a very clear definition of what maritime security shipping is. It is what we hope. Actually, it is not. ASEAN doesn't have any definition of maritime security shipping, so we have to refer to the academia to find our own definition. So according to Kenneth Hawkes, security shipping are measures employed by owners, operators, and administrators of vessels, port facilities, offshore installations, and other marine organizations or establishments to protect against seizures, sabotage, piracy, pilferage, annoyance, or surprise. In our presentations, we even narrow it down further. First, we only talk about commercial shipping, where we leave aside fishing vessels. And second, we only focus on security. We will not focus on safety, It's not just because I'm lazy. It's because it's going to be too big if we talk at the same time about security and safety. But in our writing support, in our report, research we support these presentations, we do mention also safety of maritime, safety of shipping. So first, let's have a look at some statistics relating to ASEAN cooperation on maritime security of shipping. We have found 65 ASEAN and ASEAN Plus mechanisms relating to cooperations on maritime security of shipping. We also find 79 instruments adopted by ASEAN relating to ASEAN cooperations on maritime security of shipping. And we have found countless measures and initiatives of cooperations implemented by ASEAN on security of shipping. And in addition to ASEAN, there are 5 other regional mechanisms dealing with the security of shipping in Southeast Asia. The Recap Agreement and Information Sharing Center that Professor Beckman had just described earlier. The Information Fusion Center at Changi Naval Base in Singapore. Malacca Strait Patrol between Indonesia, Malaysia, and Singapore. The coordinated patrols in the Sulu Celebes Sea area between Malaysia, Indonesia, and the Philippines. And finally, the mutual legal assistance networks between Southeast Asian states. So now we're going to look at each and every one of them. And my presentation will last until next week. I know that we are on Monday, especially some of you it's Monday morning, so I will not do that. But instead, I will group those ASEAN measures and instruments into groups under ASEAN sectorals. So for those of you who are familiar with the ASEAN system, you would know that the ASEAN sectorals are issues areas under ASEAN which would have its own mechanisms, its own instruments, its own measures. So for the security of commercial shipping, 4 ASEAN sectorals are relevant: transnational crime, counter-terrorism, cybersecurity, and maritime security. So the first ASEAN sectoral is transnational crime. Under ASEAN, piracy is regarded as a form of transnational crime with linkage to other forms of transnational crime, such as terrorism, illicit drug trafficking, illicit trafficking of wildlife and timber, trafficking in persons, and people smuggling. So the relevant ASEAN mechanisms relating to transnational crime, the most important one is, of course, the ASEAN Ministerial Meeting on Transnational Crimes, which include representatives from Ministry of Interior, Ministry of Public Security, and Attorney Generals of ASEAN member states. And of course, there are also 2 other important ministerial mechanisms, which are the ASEAN Law Minister Meeting, ASEAN Minister Attorney General Meeting on the set of the central authorities on mutual legal assistance in criminal matters. They're in charge of things like extradition of pirates. At the senior official level, we have the Senior Officials Meeting on Transnational Crimes, ASEAN Senior Legal Officials Meeting, and Senior Officials Meeting of the Central Authorities on Mutual Legal Assistance in Criminal Matters. At the law enforcement level, we have the ASEAN Council of Chiefs of Justice, which are Supreme Judge of ASEAN member states, ASEAN Chiefs of Police, and ASEAN Legal Information Authority. ASEAN has also established ministerial level consultation mechanisms at the ASEAN Plus level with regards to transnational crimes with China, Japan, and South Korea. In addition to the ASEAN Plus 3 consultation mechanisms, also a ministerial mechanism. At the same time, ASEAN established senior officials level of consultation mechanisms with India, Russia, United States, European Union, Australia, Canada, and New Zealand relating to transnational crimes. Let's have a look at some important ASEAN instruments relating to transnational crimes. The first one I would like to talk about is the Treaty on Mutual Legal Assistance in Criminal Matters among like-minded ASEAN member countries. It was adopted in 2004 between Attorney Generals and Minister of Justice of ASEAN member states. According to the treaty, the parties are obligated to render to one another the widest possible measures of mutual legal assistance in criminal matters. Those assistance measures include taking up evidence or obtaining voluntary statements, arranging for the persons to give evidence or to assist in criminal matters, effecting service of judicial documents, executing search and seizures, and examining objects and sites. ASEAN had also adopted a number of plans of actions to combat transnational crimes, with the latest one being the Plan of Action 2016-2025. According to this Plan of Actions, ASEAN member states commit to adopt a national strategy or action plan to prevent and combat transnational crimes. They strive to sign, ratify, accede, as well as implement effectively international instruments relating to transnational crimes. They utilize existing international database to facilitate and analyze critical intelligence information, such as wanted or arrested persons, organized criminal groups, and maritime offenses. They also develop training programs and conducting capacity building activities to enhance existing capability in investigation, intelligence, surveillance, detections, prosecutions, and adjudications of transnational crimes. They enhance and expand cooperation with ASEAN dialogue partners and other external partners relating to transnational crimes. Some cooperative measures implemented by ASEAN relating to transnational crimes. ASEAN had developed a model ASEAN Extradition Treaty in 2019. It was endorsed by the 10th ASEAN Law Ministerial Meeting in 2018. This model ASEAN Extradition Treaty provide model provisions for potential bilateral extradition treaty between two ASEAN member state governments. And those model provisions concern with obligation to extradite, extraditable offenses, basis for extraditions, ground for refusals, documentation, confidentiality, and arrangement for surrender.
Dang, your slides are not showing.
It's not showing?
Currently, there's no text in your
There's no, the
slides.
content is not coming since ASEAN plans of action.
Okay. Can you see it now?
Not yet.
Let me reshare it again then. Sorry for that. Is it okay now?
Not for me.
Okay. I think it's a Monday for my computer as well. Thank you for
We're all
letting me
having
know.
this same trouble, it seems.
Can you
Okay.
see it now?
Yeah.
Okay. So I think I'm just done with the 2019 Model ASEAN Extradition Treaty. The other cooperation measures under ASEAN relating to transnational crime is the development of an ASEAN Extradition Treaty. The difference with the Model ASEAN Extradition Treaty is that this latter, it meant to be for ASEAN as a whole, and the former one is bilateral measures, Model bilateral treaty for two ASEAN member states. The latter one is for the ASEAN regional, is a regional treaty. The aim of the treaty is to strengthen ASEAN resilience and capacity to combat transnational crimes and enhancing cooperation with ASEAN to ensure the respect of the rule of law. In 2021, the ASEAN Senior Law Official Meeting Working Group on ASEAN Extradition Treaty have met for the first time to develop the first draft, and they plan to finish it in 2 years. So it means we are probably see the first draft of the ASEAN Extradition Treaty in 2023. The second ASEAN sectoral relating to maritime security of shipping is counter-terrorism. ASEAN tried to prevent, to enhance maritime transport security against terrorism, and it tried to prevent the use of containers or ships by terrorists for terrorism purpose. It also tried to enhance protections of critical infrastructures, including seaports, against terrorism. So ASEAN mechanism relating to counter-terrorism, we have the ASEAN Ministerial Meeting, ASEAN Defense Ministerial Meeting, and ASEAN Ministerial Meeting on transnational crime. At the senior official level, we have the ASEAN Senior Officials Meeting, ASEAN Defense Senior Official Meeting, ASEAN Senior Official Meeting on transnational crimes. At the law enforcement level, we have the ASEAN Chiefs of Defense Forces Meeting, ASEAN Chiefs of Navy, ASEAN Chiefs of Police, and the ASEAN Coast Guard Forum. The ASEAN Coast Guard Forum was supposed to meet in 2019 for the first time, but it was postponed due to COVID-19. Since then, they have never made up for again. They have never met again for the first time. At the ASEAN Plus level, we have the Post-Ministerial Conference 10+1, ASEAN Regional Forum, and ASEAN Defense Minister Meeting Plus. Some ASEAN instruments relating to counterterrorism. The first and the most important one, the most important regional instrument under ASEAN relating to counterterrorism is the ASEAN Convention on Counter-Terrorism 2007. It aimed to establish a framework for regional cooperation to counter, prevent, and suppress terrorism. It covers, as Professor Beckman said, all the offenses under the so-called UN Counter-Terrorism Conventions. I think there are in total 19 of them, and they cover offenses such as seizure of ships, seizure of aircraft, kidnapping, bombing, and terrorist financing. ASEAN also adopted a number of plans of actions relating to counter-terrorism, with the latest one being 2018-2025. According to these planned actions, ASEAN member states commits to adhere to relevant UN Security Council resolutions and relevant international instruments, implement existing regional instruments, exchange of best practice on how to protect critical infrastructures and critical information infrastructures, including seaports, and develop integrated surveillance and movement control methods at vulnerable areas among common borders in ASEAN member states, including the maritime borders. At the ASEAN Plus level, ASEAN has adopted instruments for cooperation to combat terrorism with the United States, India, European Union, Japan, Australia, Russia, Pakistan, Republic of Korea, New Zealand, and Canada. At the same time, a number of statements and declarations relating to counterterrorism have been adopted under the framework of ASEAN Regional Forum and ASEAN Defense Ministerial Plus. Some cooperation measures relating to counterterrorism under ASEAN. ASEAN had adopted a shared database of websites relating to terrorism, which have on the website which propagate extremisms and terrorism ideologies and ideas, where only ASEAN officials in charge of counterterrorism can get access to them. The ASEAN 365 information sharing platform, where only agencies in charge of counterterrorism in the ASEAN member states could contact with each other in interactive mechanisms and in real time. So if you have any issues, you can contact your counterpart right away. ASEAN Our Eyes initiative is also an initiative to share information, to share intelligence between ASEAN member states using existing secure platforms. The virtual network of ASEAN chemical, biological, and radiological defense experts, which are you have the network of all you have the name and the coordinate information of all the ASEAN national experts in chemical, biological, and radiological weapons. So if you need to contact any of them, you can go to this network, and at the same time, they would have coordinative actions and have exchange information through this network to enhance effectiveness to fight against those types of terrorism. The third ASEAN sectoral relating to maritime security of shipping under ASEAN is cybersecurity. Under ASEAN, cybersecurity includes, inter alia, protection of critical infrastructures, host failure or limited operations due to natural or man-made disasters will surely cause tremendous impacts on the vast majority of citizens. Those critical information infrastructures also include those network to monitor ship, also network to enhance safety of ship or to manage ports. So, and I'm sure that if those are hacked, if the security of those are compromised, it would cause devastating impacts on the life of a lot of people. So ASEAN mechanism relating to cybersecurity. At the ministerial level, we have the ASEAN Digital Minister Meeting and ASEAN Ministerial Conference on Cybersecurity. At the senior officials level, we have the ASEAN Digital Senior Officials Meeting, ASEAN Japan Cybersecurity Policy Meeting, and Telsom Plus ITU Meeting, which is the former Telecommunications Senior Official Meeting plus International Telecommunication Union. I think this has stopped now. At the law enforcement level, we have the ASEAN Telecommunication Regulators Council. At the expert level, we have the ADMM plus ASEAN Defense Ministerial Meeting plus Expert Working Group on Maritime Security and Cybersecurity, and we have the ASEAN Cyber Defense Network. At the operational level, we have the ASEAN Information and Communication Technology Center, ASEAN Defense Ministerial Meeting Cybersecurity and Information Center of Excellence. You also established a number of dialogue mechanisms with our partners. For example, the ASEAN-India Track 1.5 dialogue on cyber issues, ASEAN-China Cyber Dialogue, ASEAN-United States Cyber Policy Dialogue, and ASEAN-Japan Cybercrime Dialogue. Some ASEAN instruments relating to cybersecurity. In 2017, ASEAN adopted a declaration to prevent and combat cybercrime, in which ASEAN member states commit to sign, ratify, and implement all existing international and regional instruments relating to cybercrime. ASEAN data management framework, which is non-binding guidelines for ASEAN to make its ecosystem for e-business becoming safer. ASEAN Information and Communication Technology Master Plans, with the latest one being the ASEAN Digital Master Plan 2025, which have as objective to make ASEAN by 2025 become a resilient, efficient, and safe ecosystem for business, especially e-business. At the ASEAN Plus level, ASEAN adopted an MOU on cooperation in information and communication technology with China, and statements on cybersecurity cooperation with the United States and the European Union. In terms of cooperation measures, the most important cooperation measures relating to cybersecurity under ASEAN now is the ASEAN Computer Emergency Response Teams. It means that ASEAN will try to create in each ASEAN member state a national computer emergency response team who will deal with emergencies, incidents, cybersecurity emergency incidents whenever it happens. And those national teams can cooperate, can coordinate with other counterparts in other ASEAN member states in order to enhance the effectiveness of activities of action. The fourth ASEAN sectoral relating to maritime security shipping is maritime security. And the understanding by ASEAN of maritime security is conventional. It includes conventional maritime security issues such as military threats and state sovereignty concerns, as well as non-traditional maritime security issues such as piracy, terrorism, natural disaster, climate change, smuggling of drugs, people and goods, search and rescue. It means that ASEAN also adopted the concept of maritime security, which is well known worldwide. And the concept of maritime security that we know is very broad. I think Professor Beckman at one says maritime security is like an empty vessel where you can put in a lot of things, people and goods. Same in ASEAN, maritime security sometimes also understood that include prosperity, economic prosperity. And maritime security shipping is a component of maritime security. So under ASEAN, the most active mechanisms relating to cooperation relating to maritime security maritime security is the ASEAN Regional Forum. And most recently, you have also established the ASEAN Maritime Forum and expanded ASEAN Maritime Forum. So under the ASEAN Regional Forum, an intersessional meeting on maritime security was established in order to focus on enhancing the cooperation of maritime security in ASEAN. And under ASEAN Regional Forum, a number of work plans for maritime security have been established, been developed. I think 3 have been developed so far in order to define the priorities for corporations relating to maritime security under ASEAN and under ASEAN Regional Forum. The most latest ones is the 2018 and 2020. No newer one have been adopted. The cooperation measures relating to maritime security. It was established in ASEAN Regional Forum Regional Maritime Information Center in 2001 to share information intelligence among ASEAN Regional Forum participants for better cooperation and coordinations. Unfortunately, this information center has stopped working now. In 2013, under ASEAN Defense Minister Meeting Plus, a maritime security community information sharing portal was established to foster practical defense and military cooperation by aiding information sharing between ASEAN Defense Minister Meeting Plus countries. I think that this sharing portal must be confidential or something, because I tried to look it up online and I couldn't find anything. I would like to make some recommendations on how to improve ASEAN cooperation with regards to maritime security shipping. Our first suggestion is that the cross-pillar communications and coordination between political security and economic pillars or communities among sectoral mechanisms of ASEAN dealing with maritime security of commercial shipping should be improved. So you can notice that under ASEAN, there are the ASEAN sectorals dealing with maritime security shipping arranged into two pillars: the ASEAN Political Security Community, or pillars, and the ASEAN Economic pillars. The ASEAN Political Security Committee, or pillars, include the ASEAN Ministerial Meetings, ASEAN Defense Ministerial Meetings, and ASEAN Ministerial Meetings on transnational crimes. Whereas the ASEAN Community pillars include the ASEAN Transport Minister Meeting and ASEAN Digital Minister Meeting. And we all know that the coordinations and cooperations between different ASEAN sectorals, especially when they are from different pillars, are not that great. They don't have that much exchange with each other, and they work somehow in a silo. And it's not only true with the issues of maritime security shipping, it's also true with other issues in the ASEAN. And I think it would diminish the effectiveness and the efficiency of ASEAN actions. So we would like to recommend, to suggest that ASEAN would find a way to enhance the exchange, the interagency coordination between different ASEAN sectorals, especially when they are from different pillars. That way we can enhance the effectiveness of ASEAN cooperations in maritime security shipping. Second, we suggest that ASEAN should encourage its member states to ratify the 2005 protocol to SUA conventions. As Professor Beckman had explained to you in his presentations, this deal provides a very important basis for cooperation relating to counter-terrorism against shipping. So if the SUA Convention of 1988 have almost all ASEAN member states as the parties, except Thailand, Indonesia, and Malaysia, which unfortunately are very important shipping nations in ASEAN. The 2005 protocol to this convention had no member from ASEAN member states. And if ASEAN can push or can encourage ASEAN member states to ratify this protocol and all ASEAN member states to ratify the conventions, it provides a very strong basis for cooperation to fight against offenses, against the safety of navigation, the safety of shipping, not only at the ASEAN level, but also at the global level. Maybe the third suggestion is that maybe ASEAN could consider establishing a permanent mechanisms to discuss the issues of maritime security of commercial shipping. So as we have seen, shipping is a very important industry in ASEAN. Many ASEAN member states are world top commercial ship fleet. For example, Singapore, Malaysia, Indonesia, Philippines, and Vietnam. And maritime security of shipping is critical for the industry to thrive, not only in Southeast Asia, but also in other parts in the world. So I think the issues of maritime security shipping deserves to have its own permanent mechanisms for corporations in which all ASEAN member state representatives could meet regularly, could discuss, could exchange information, and could suggest more cooperative activities to enhance the security of shipping in the region. ASEAN could also engage more deeply with the dialogue partners on the topic of security of commercial shipping. If you look at the dialogue partners of ASEAN, you see that many of them are very important shipping nations. For example, Republic of Korea, China, India, the European Union, Japan, Russia, and the United States. So they also have a lot of interest to improve the security of shipping worldwide and in Southeast Asia. So I think there's a lot of rooms for ASEAN and those countries to deepen their cooperation, to deepen their exchange, their coordination, to have a mutually beneficial cooperation relating to commercial shipping in order to enhance the situation of maritime security shipping worldwide and in Southeast Asia. To conclude, a very well-known ASEAN scholar, you all know whom, has said, international organizations move very fast after a disaster. It's not only true for ASEAN, it's also true for other international organizations such as IMO. Whenever there's a maritime accident, they will create a new treaty. But this time, we really hope that ASEAN will not wait until there is a disaster in maritime security in the region to take actions. We hope that ASEAN could be more proactive to foresee the situations and to adopt actions before any kind of maritime security accident to happen in Southeast Asia. That way, ASEAN will enhance its centrality. Thank you.
Thank you very much, Dan, for your presentation and really for giving us a rundown of that wealth of instruments relating to maritime security in the ASEAN. And there really are so many instruments. And perhaps more than the prosecutorial value of these instruments, at least we know that there is a vast groundwork for further cooperation in law enforcement and maybe even innovation, as you talked about in your slides on cyber security and others. I guess we can start the open forum or the Q&A with the first question in the chat box from one of our guests, Mr. Javier Rosas. The question is whether UNCLOS helps or deter maritime security. So maybe it's not, the question is really not just about UNCLOS, but all of these instruments, the whole legal framework. Are there ways by which the number or the sheer number or the organizational framework for all of these legal instruments actually deters maritime security? Prof, maybe we can start with you if you have a response to that.
I'm not sure that the near number deters or enhances maritime security. I think what we're trying to focus on is what are the gaps that are needed to address maritime security. And I think, as Dang has pointed out, the one major gap, I think, is terrorist attacks against shipping or using ships as weapon in terrorism, where there is the SUA Convention Protocol of 205, which is intended to create international crimes on this, but this convention has been ignored. It's been ignored by, last time I looked at the list, there was no state between Turkey and New Zealand that was a party. No South Asian countries, no Southeast Asian, or no Southeast Asian countries are party. It's primarily Europeans, Latin Americans, Pacific Islands that are parties. And the threat of maritime terrorism against shipping is still real, right? We had, after 9/11, there were scenarios, what if a tanker were, terrorists attacked a tanker in the Strait of Malacca or in the Singapore Strait, it would cripple shipping, etc. But after that initial concern, because there haven't been any terrorist attacks by using ships or against shipping since the early 2000s, I think it's been put on the back burner by everybody. And therefore, this to me is the major gap. The other problem I see with ASEAN is that ASEAN is looking at, they're calling piracy a transnational organized crime that's linked to other crimes like hijack, or which I didn't see the connection. And I don't see that it's necessarily a transnational organized crime, is the way I normally think of that term. And therefore, perhaps it's under the wrong pillar. The pillar that perhaps should be looking at this, it should be labeled under the Counter-Terrorism Conventions. And it's the ASEAN officials that are responsible for counterterrorism should be looking at whether it would be in the common interest of ASEAN to have all its members ratify the SUA Convention, because there is a 205 ASEAN Convention, which enhances the cooperation that would exist under the SUA Convention and under the SUA Protocol. The ASEAN Treaty goes even further, but it applies only when all the parties in ASEAN are parties to the underlying convention. So the gap again is no one's a party to the major convention on terrorism by or against shipping. And once three states are not parties to the SUA Convention, which could be a useful tool to deal with certain attacks on shipping, and incidents like the Abu Sayyaf kidnappings would be the Convention on Hostage Taking could have been a tool there. So what we have left in ASEAN is that at a sub-regional level, the states concerned have cooperated with each other to tackle the problem. I think my understanding is Philippines, Malaysia, and Indonesia cooperated to deal with the taking of hostages of crew members in the Sulu-Sulawesi area. The Malacca States Patrol's cooperation between Indonesia, Malaysia, and Singapore dealt with that together with cooperation by RCAP. So ASEAN as such has not done anything. On the other hand, on the counterterrorism conventions, ASEAN's created the legal framework. It's just that the member states have not given a priority to ratifying the 205 SUA protocol. And that to me is still the key gap in the whole process. And exactly which pillar that would be on problem, I think, as Dang pointed out, is shipping's under the economic pillar. And political security pillar, they probably have so many other priorities. They're given cybersecurity a higher priority. They haven't looked at terrorism against shipping as a high priority. And that's, again, perhaps it's a lack of a link between the pillars. Sorry for the long dialogue, but.
No problem, Prof. I think you touched a little bit on the heart of the next question, actually, but if I welcome you to add to your earlier remarks, because it's about, what do you think is the actual bottleneck on the uptake of the 2005 SUA protocols in the ASEAN region? You already mentioned that it's not a priority, but is there anything more specific than that, if anything?
I don't know of, again, I'm not a government official. I don't know of any bottleneck. I was shocked when I found that neither Japan nor South Korea are parties, and they're normally a party to all the major conventions. Australia, at one point, I got notice that they were going to become a party, but they still have not. New Zealand is a party. I think one of the bottlenecks I understand from talking from government officials or to government officials from the US and from New Zealand is that it's one of the most difficult implementing legislation tasks that they've ever encountered, because the security of shipping required so many government agencies to cooperate, to review the existing laws, and then to create the necessary offenses on terrorist attacks on shipping. And that is one issue. The other issue, I think, is that it's an IMO convention. And the delegates to the IMO are the transport ministry. They are not experts on terrorism. They're not experts on international crime. So I view the 88 SUA and the 205 SUA sort of stepchildren of the IMO. They were given to the IMO because IMO, it covers shipping and IMO does shipping. But IMO does safety and pollution. They don't really do security. And therefore, and there's no international agency that, I guess the International Office of Drugs and Crime deals with transnational organized crime. It deals, but there's no agency to implement the so-called counter-terrorism convention. So the issue falls between the cracks in national governments, because who's going to take the lead is the issue. The transport ministry have a lot of other priorities. The defense and security people have a lot of other priorities, and it doesn't come to the top of the agenda. And that's the same at the ASEAN level. They hats off to their 205 treaty on cooperation on counterterrorism, but then the question is, major counterterrorism convention on shipping has not been ratified and nobody's pushing for it. That, I think, is the problem. Now, I can't answer why. I'm not in government.
Thank you, Prof. Dan, would you like to add along the same lines of the first two questions?
Okay. In addition to what Prof. Beckman have said, I just want to add that these conventions, including UNCLOS, they was adopted and they meant to enhance maritime security of nations. They meant to enhance the cooperation between nations in order to improve the situation of maritime security globally. However, because of worries of states, of member states, and because of worries about implementations of those conventions, that those states, they didn't ratify, they signed, but they didn't ratify those conventions, which make it very difficult, which become a bottleneck, as you put it, for the improvement of cooperation worldwide and at the regional level, relating to maritime security. Very unfortunate, because these conventions, these treaties were meant, was signed, was created, but developed, which they meant to become an instrument for corporations, and at the end they become bottleneck for corporations because of the fear, because of the implementations, fears of those states.
Thank you, Dan. I think the next question, which actually came from our registration form for the webinar, is actually very broad, but will probably give us a lot to think about. The question, and I'm paraphrasing, is how do we measure maritime security in each ASEAN country? And the context given was that as maritime security relates to the level of economic prosperity of each country, and maybe issues in corruption, governance, crime, law enforcement, etc., within those countries. What is our scorecard? What are the items that we should be considering? And what is your framework for evaluating the level of maritime security in the region? Prof or Dan?
Well, again, maritime security to me is an empty vessel in which everybody pours their own wine. What do we mean by maritime security? Sometimes I hear discussions where people throw food security into it, or they throw poverty, and they throw everything into the barrel of maritime security. That's why we're focused in this on, I don't know how to measure maritime security because I don't know what it means. The question we're having this one is international shipping secure in the country? Is there a threat to the security of commercial shipping? Then I know what we're talking about, right? But when I say maritime security in general, it historically meant maritime security was meaning threats from other states in your maritime space. But now it has become, it's linked to food security, it's linked to the Agenda 20, the UN goals, the development goals, it's linked to everything, which means it's an empty vessel. Who's in charge of maritime security? Is it your maritime agencies? Is it your security agencies? Is it whatever? I think that's the problem. I would move away from the broad, undefined term and start looking at specific issues to say which government agencies are responsible for this. And the key problem in most governments and the key problem at the global and the regional level is when an issue is complex enough to fall between the cracks, so that no one agency is principally responsible at the national level and no one agency at the regional or international level. IMO is not really, maritime security is not its #1 priority. The IMO, as far as I know, doesn't give any attention to ratification of SUA as a priority because it's worried about many other issues relating to its main mandate, which is safety and ship source pollution. That's what I say, it's a stepchild of the IMO. And I think that's the underlying issue. So I don't know how to measure maritime security because I don't know what it means, right? I need a definition.
Thanks, Prof. It's a question fit for a PhD project, actually. Dan, any thoughts?
I totally agree. Since it's an empty vessel, we can't really measure maritime security. However, if you break it down, you have many indicators and index for each component of this maritime security. For example, if you talk about fisheries, you have the IU Fisheries Index, which measures the performance of each countries on how to prevent illegal, unreported, and unregulated fishing. If you talk about corruption, you have the Global Transparency Index, which measures the level of transparency of each country. We talk about economic prosperity, you have the well-known GDP, but we don't have any general universal index to measure maritime security. Maybe, as you say, maybe you can create one by having a PhD thesis on that. Maybe it could be a sum of all those measures, on those existing index on each components. But again, it's a very broad area. So so far, and especially in the ASEAN, we have no ranking or no index to measure maritime security. Maybe you can, if you want to look about safety, you can look at IMO reports, or you can look at the recap reports or the IFC reports for safety, for piracies, incidents. But as maritime security as a whole, maybe you want to develop a new one about that. Thank you.
Right. So the answer really is very broad and very specific at the same time.
Maybe I could help by let me give one more example of an issue which I think is similar to what I'd call security of shipping or terrorism against shipping, and that's the security of fiber optic submarine cables. It's in one of those cases where the lead agency for submarine cables is often the telecommunications agency, but the security of cables in many countries falls through the cracks because it's not, the telecoms is usually in the economic pillar, and they're thinking about enhancing connectivity within their country, global connectivity, and they're not thinking of the security of the infrastructure or the security of the cables offshore. To deal with that, you must bring in all the maritime agencies and the political and security agencies. And therefore, in many countries, the whole issue of security of critical communications infrastructure, meaning telecoms infrastructure, falls between the cracks, and no one's dealing with it. It's a very similar issue, where a narrow reading is one ministry handles its portfolio, but the political security aspects of that are not dealt with by anybody, because you'd have to go across to all the security folks who generally don't know anything about submarine cables. That's part of the problem. But it's coming, cybersecurity aspect of it is being looked at, but not as much the physical security aspect.
Thank you, Prof. You have intuited the substance of the next question actually on the chat box, which is, how should the security of undersea cables be addressed by international law? So you have given us the background. The question is, how should we address this?
Well, it's one of those issues I raised where people asked me that. I said, well, which UN agency is responsible for submarine cables and the security of submarine cables? And the answer is none. That is the underlying problem. At least in national governments, you know that it's usually the telecommunications ministry that is responsible for telecoms, and submarine cables being one aspect of telecoms. But the security of it, the prevention of cutting of cables offshore, prevention of attacks on your cable landing stations, whatever, requires, again, a very interagency cooperation at many levels. And many countries have not yet organized themselves very well to address this issue. Because in discussions I've had with government officials in ASEAN regions, they say, well, gee, this would have to go to the president, or would have to go to cabinet. They would have to designate a lead agency and decide who else cooperates. And we don't have a mandate to address that. So until somebody takes it up to the highest authorities, the problem's left unaddressed. And I think I would look at perhaps terrorist attacks on shipping that could block straits or so on, and terrorist attacks on submarine cables as two of the areas where it would be in the interest of ASEAN to give a much higher priority.
Thank you, Prof. Dan, do you have another approach to this question?
Yeah, I would like to add some additional information. There is no international treaty dealing with submarine cable, security of submarine cables. The UNCLOS dealing with the rights, the freedom of laying submarine cables in general, but not security. However, in some national laws, they have something called the law to protect the critical information infrastructures. And submarine cables belong to those categories of critical information infrastructures where they provide better protections of the cables. But at the international level, nothing yet. It depends on each country. And I hope that it's coming along. Means those countries which, because submarine cables, they go through the exclusive economic zone of many countries. So maybe in one country, you have the law to protect those submarine cables under the general category of critical information infrastructure. In another country, it's not. So I think there's a need, as Professor Beckman put it, to have a maybe at first a regional treaty or a regional agreement to protect those submarine cables as a important or critical information infrastructures, and then we can develop a international treaty on that based on those those national laws on protecting critical information infrastructures.
Okay.
Let me add one more point, Pia. I think in discussions I've had in many countries, I did some work for UNODC on this. Many government officials don't understand that 98% of their telecommunications is by fiber optic submarine cable under the ocean. They're under the mistaken impression that their phone calls are all by satellite, whatever, and satellite is perhaps 1 to 2% backup if your cables are cut. So I think there's some general misunderstanding about the importance of cables, but also because cables are owned and laid by private companies these days rather than by governments. There's also a question of how do the governments cooperate to regulate them and to ensure that the infrastructure is protected. It's an area where you need if destruction of airport facilities is an international crime under one of the IMO or one of the global conventions, and destruction of port facilities. It's certainly destruction of cable facilities should also be an international crime, a counter-terrorism crime. But we haven't gotten that far, and we're a long way to go. Partly because there's no agency at the regional or global level that's responsible.
Okay. Thank you, Prof. and Dan, for that exchange. We have a new question that just came in. As far as cyber maritime security is concerned, is there an issue with classification or sensitiveness of information that can be shared, which may hamper the capacity of actors to enhance global security?
I'm not sure. I wish he'd be a little more precise on that. I'm not sure exactly what the author has in mind. I think some states are perhaps reluctant to provide information to the extent that there is unauthorized boardings of ships in their territory. I'm not sure to what extent all the information is shared. I know RCAP and IFC are looking at this, to what extent it's shared, to what extent perhaps shipping companies sometimes are reluctant to report incidents of attacks on their ships because they might be required to come into the nearest port for an investigation that will slow their voyage down by hours, if not days, and time is money in shipping, and the ship owners and operators may not be happy that their travel was delayed, etc. So there may be reluctance to report sometimes on industry if they don't think that actually problem's going to be resolved anyway. There may be reluctance on some states to report on the number of incidents in waters under their jurisdiction because it looks like their seas are a little bit lawless, etc. And so this might affect the statistics a bit. I think the question of how do we encourage the best data possible, how do we encourage reporting so that we know much more, we have much better data on what the existence of the threat is, and then the ship owners and ship operators and governments can respond accordingly. If you're dealing with half information, you might not have a best solution.
Thanks, Prof. I think you hit the right points. The follow-up comment is that the question relates to the conduct of commercial companies where information sharing is not, not very ideal, perhaps, for the author. Dan,
And I think that's something where the recap IFC that has, I think, works with the companies. It's a question of, can they get the companies to cooperate? And I guess this relates back to your piracy reporting centers. You have the IMB in Kuala Lumpur, and you have the recap in Singapore, and then you have IFC. It's a question of, who does the shipping company report to, and can you get a common, and what do they report, and how soon do they have to report it, right? That's the underlying issue. But I can understand the viewpoint sometimes of industry that say, well, time is money, and if it's a minor boarding, I'm not going to wait 12 hours going into port and if I have to go into port in order to report it, because we then commercially, we lose much more than we gain. I think that's an issue that has to be addressed.
Dan?
I would like to add that under international law, there's no obligation for company to share their information relating to cybersecurity, especially these maritime shipping companies. And under national law, I think they are only obligated to share with the relevant authorities. They are not bound to share with other companies. But to improve the situations of cybersecurity of the shipping industry as a whole, I think it would be a good practice for companies to share data, to share information relating to cybersecurity among themselves. It's not a legal obligation, but it would be good for preventing cybersecurity incident to happen to those companies. So maybe we could think about developing an obligations, or a best, I wouldn't say legal obligations, but a best commercial practice for shipping companies to share between themselves about those cybersecurity attacks, those cybersecurity issues, so that the whole industry could improve the state of cybersecurity as a whole. Maybe it could be developed as a lex mercatoria regulation. That would be my suggestion. But currently there's no law on that.
Let me add on that. I think I didn't realize it was cybersecurity. I missed that part of the question. Again, I'm not sure the IMO has ever looked at this, but what it would be, it's the IMO that decides if they could work this under the SOLAS Convention and what are the other convention, then it's the flag states could require shipping companies to report. Now the question is, can you get laws that are in place? Do you have a common reporting standard that is not going to prejudice the economic issues with respect to a particular company? But the more information that were shared, and then if there was central authority to study that information and give the requisite warnings, whatever, I think if the industry saw the advantage of sharing and it wasn't going to hurt them economically, then they would probably be more than willing to share. If not, the IMO, in theory, under SOLAS and one of the other conventions, legally probably could require it through flag states requiring the owners to report. But it's the IMO moving into security when it really worked, that's a different issue.
I believe the issue certainly has figured into IMO discussions, and there are guidance documents. But as Dang said, there is no legal obligation under international law, not exactly in the sense of the legal obligations that we know. Another question that we have from the registration form, which is more contemporary, is as to the role of the IMO and ASEAN with respect to developments in the conduct of the coalition of countries that are condemning Russian action in Ukraine, particularly in circumstances where navies are being used to interdict commercial oil tankers. with commercial contracts with Russian shippers or consignees or other Russian entities that may be affected by sanctions?
I'll take a pass on that one because I have not looked at the issue carefully enough that I would give an opinion or make a comment. Exactly, interdicting a ship that's flying a foreign flag is a very serious, because again, the general principle outside the territorial sea is the ship is subject to the exclusive jurisdiction of the flag state. You normally don't want to interdict another ship, even if it's counterterrorism, unless they come into a port. So interdicting a ship on the high seas, unless it's piracy, is a very high-risk venture. And I have to see the legal analysis of how this is justified or exactly what they're doing. And I haven't come across the documents on this.
Dan?
Yes, it is quite difficult questions in a way that it is quite broad. There are two kinds of sanctions, and I think both of them would not be in this case. The first kind of sanctions, which are sanctions that are adopted by the UN Security Councils against the country. If the sanctions are adopted by the UN Security Councils, then all the countries in the world have to respect it and have to enforce it. Like, for example, the case with North Korea. All the coastal countries would have the duty to prevent its ships or other ships from other countries to transport nuclear materials to North Korea. But it is not the case with Russia, because Russia is a permanent member of the UN Security Council. It's a veto right, so there will never any sanctions from the UN Security Council against Russia. As for sanctions that are adopted by countries individually or by group of countries, I think that actually IMO have no obligation to enforce those sanctions. Only the countries that adopt those sanctions that have the obligation to enforce them. As for ASEAN, I remember in the past, ASEAN has also adopted sanctions against other countries and against its own member with regard to the conduct of these kind of nations. But again, ASEAN would be neutral on the issues between Ukraine and Russia. So I don't think ASEAN will adopt any sanctions against either of those countries.
Yeah, let me go back to basic principles. You cannot intercept a ship on the high seas unless it's piracy. That's your starting point. Now, any state can deny entry into its port of a vessel. So if the sanctions of the cooperating countries are denying entry into port, that's perfectly lawful. But the ship would have a right of transiting its territorial sea. The ship has navigational freedom on the high seas. And without the consent of the flag state, that's the fundamental principle. Once you're outside the territorial sea, the ship is subject to the exclusive jurisdiction of the flag state. So I'd have to look at an exact scenario and exactly what's going on to give any general or give any advice on that or give an opinion.
Okay, we have one question, also fresh from the Q&A box from Charlie Brown. He says, we've seen coalition maritime security arrangements in the Middle East, for example, the Combined Maritime Force, which included CTF 150, 151, etc., and the International Maritime Security Construct and EU NAV4, etc. How do these arrangements fit within the legal framework that we've been discussing? Would proposals for similar models ever be likely in Southeast Asia, perhaps under the framework of the ASEAN or outside it?
Okay, regards to Charlie, an old friend. The cooperation of the coalition off Somalia was pursuant to Security Council resolutions making allowing the arrest of vessels within the territorial sea, and having language, I can't remember the exact wording, but the states cooperating with the transitional national government of Somalia were able to cooperate to combat the attacks on shipping. So it was with the consent, to the extent it governed attacks within the territorial sea of Somalia, the consent was there, or the exception was made by the Security Council acting under Chapter 7, and the Security Council itself created the mechanism for this to happen. In West Africa, I haven't looked at the exact legal framework of how it is happening, but my guess it is cooperation among like-minded states outside the territorial sea. But to the extent to which they are arresting or boarding vessels outside of territorial waters without the consent of the flag state, that I am not aware of. I think they might be cooperating with the Nigerian authorities off the coast of Nigeria, etc. The prospects of this happening in Southeast Asia, nil. I don't think the Southeast Asian countries came out of colonialism, many of them at the end of World War II. They jealously guard their sovereignty, and they are never going to allow a coalition of outside powers to patrol their waters. I think it's a non-starter. I've raised this at several meetings, and it's very clear that, in fact, I believe that in the resolution that authorized this cooperation in Somalia, a clause was inserted in that resolution at the request of the Indonesian representatives that this arrangement could not constitute new customary law, it could not be used as evidence of customary law, and it could not be used in other regions. And I think that was in the resolution, and it was also included in every subsequent resolution that renewed the mandate. And that again was demonstrating that this was a unique situation in Somalia in which the official representatives had requested assistance, and that it could not be used as a precedent anywhere else. That's my take on that. Yeah. Dang. Were you going to say something?
Yeah.
No.
Yeah. I agree that our traditions, the Southeast Asian traditions, is not to have those kind of hard arrangements. And ASEAN, what it does best is to provide a dialogue mechanisms, a forum for relevant agencies to come in and to talk and to exchange information to enhance their cooperation. So, and there are a couple of them in under ASEAN. For example, the prospective ASEAN Coast Guard Forum, which was supposed to meet in the Philippines in 2019, but it was postponed until now because of COVID-19. And other fora between maritime law enforcement forces, for example, the Chiefs of Navy's Forum, the Chief of Police, the Chief of Defense Forces meetings. So those are the kind of arrangement you're going to see in ASEAN. It is in accordance with the ASEAN way, which we will not have any hard arrangement, any few arrangement, but we will facilitate talks between the relevant parties, including the parties outside regions, in order to enhance their mutual understanding, their coordinations, and then they will develop their own cooperation. It's the way that ASEAN moves. So you will not see any hard arrangement, any few arrangement, maybe some ad hoc exercise between relevant parties. For example, the one between China and ASEAN member states, or the one between the US and ASEAN member states. But within ASEAN will only serve as a facilitating mechanisms for those forces to meet with each other and to discuss, to exchange information.
Let me give one more example of this similar arrangements. There's the so-called ship rider agreements in which countries like the US would help the Caribbean countries or Pacific Island countries prevent drug offenses, etc. again, my discussions with officials in this region is a non-starter. The countries in this region would regard this as an infringement on their sovereignty. They would never accept the foreign vessels patrolling their waters, even if it had a representative on board who was representing their interests. The position of the ASEAN countries would be, if you want to assist us, give us ships and give us training. But we don't want your ships in our waters. I think that's the bottom line in Southeast Asia. I'm quite confident that that would remain the line for the foreseeable future.
Thank you, Prof. And indeed, the comments are more or less the same about the attitudes in the region. I don't have any further question in the chat box. If there are any final questions from the audience, now is the time to type them in. If I don't see any other question, I guess we can conclude with a general question that you can conclude with on how are the, well, we have been discussing the IMO and the ASEAN, and clearly they're not exactly the same kind of international organization or intergovernmental organization. They're not the same organism. How are their approaches similar? How are they different? How are they effective? And how are they wanting? Since we pulled them together in this webinar, I guess you can all leave with a comment on that.
Oh, okay. Well, I guess the IMO is the rulemaking body in the areas of its competence, which would be ship source pollution and safety of navigation, and to a much more restricted sense, security of shipping. And the IMO treaties are such that they're automatically, the new rules are automatically, through tacit acceptance procedures, binding on all member states. And virtually all member states are parties to the IMO conventions. So the IMO is simply a rulemaking body. The ASEAN countries and all other countries are obliged to implement, and they do faithfully implement the IMO rules. ASEAN is completely different than that, I think. ASEAN is, and ASEAN really has no role in assisting the member countries in implementing IMO conventions, unless the IMO convention recommended regional cooperation at some kind of level. And the ASEAN is not a rulemaking body, and its declarations or its conventions are automatically binding on member states. It'll create a convention, but then it's up to each state to decide whether or not it's going to ratify that or not. So they're very, very different. I guess what we were struggling with here is, to what extent is there a role for IMO, for the regional body ASEAN, in examining particular issues like the security of shipping. And I see that they played that role very well with respect to maritime terrorism in general, but then the gap is that their members have not ratified the one major convention on terrorism against shipping, and that's the 2052 protocol. And that's where perhaps the IMO, not the shipping pillar, but perhaps the political security pillar, could be looking at the pros and cons of giving a priority in the region to the ratification of the 205 protocol. That's, I think, where we're coming from at the end of this dialogue.
Okay, thank you, Prof. Dan?
I totally agree with Prof that ASEAN doesn't exist in parallel with IMO in terms of creating norms for maritime security shipping. What ASEAN has done is to facilitate the adoptions by ASEAN member states of IMO conventions and treaties. For example, on the one relating to safety of navigations, and in case another on the downstream part, once those treaties and conventions have been adopted, have been ratified by ASEAN member states, ASEAN can play the role of facilitating the enforcement of those treaties, those instruments by ASEAN member states. And ASEAN does that by providing capacity building, by providing training workshops, by providing on those support tools such as shared database, such as cooperation with other partners, to facilitate, to give the technical resources, the financial resource to ASEAN member states to reinforce the implementation of those conventions. And sometimes ASEAN does talk to IMO and to get help from the IMO to implement those conventions, those treaties within the Southeast Asian region. And it's a mutual beneficial way. IMO have its treaties better implemented, and ASEAN member state capacity improve to implement those treaties.
Okay, thank you. We have 10 minutes left, but I see no further questions in the Q&A.
May I make a publicity announcement?
Yes.
Well, CIL has developed a research guide to the IMO, and the major author of that is our chairperson, Pia. And we would be very happy to either share our report on two things, share the draft report we have on ASEAN and maritime security. But for those in the audience that do work on the IMO and attempt to find IMO documents or attempt to understand all of the symbols and so on that IMO uses and how it's organized, we've developed quite a comprehensive guide to the IMO, which is intended to assist government officials and academics and young researchers on understanding the IMO and understanding the document. So if people are interested in that, it will be on our website quite soon. In the meantime, anybody in the audience that might be interested in obtaining a copy, you could send us an email and we would be happy to send that to you.
Thanks, Prof.
Maybe can I add something?
Sure.
we will send you the copies at one conditions. You have to help us improve our reports by giving us your comments and suggestions. Thank you.
That's a good one, yes. It's a real dialogue. Yes, and we do have another publicity announcement. We will talk about more on the IMO resource that Prof just spoke on tomorrow at our webinar on recent developments relating to maritime autonomous surface ships. Also a hot topic before the IMO, and definitely something that a lot of states are interested in being at the forefront of, and something probably that is also a priority area for the ASEAN region in the next 2 to 5 years, as we are crafting the relevant rules for this new kind of organism in the field of maritime affairs. So we hope that you would register for this webinar tomorrow. We all wish you a happy Monday. Thank you very much to Prof. Beckman and Dan for that great discussion. We also thank our editor, Dr. Rcl, for opening the proceedings today. And we wish you a great rest of your day wherever you are in the world. Bye-bye. Thank you.